We have with us A.J. Ferrari. He is of counsel at the Oklahoma City law firm Spencer Fane. He is well known in conservative circles for assisting many candidates for office and the Republican Party. But the reason that he's most appropriate for this conversation is he worked on the original case, the Murphy case, and he will explain how the Murphy case fits into the McGirt case when we come to him in just a minute. Also, we have Rick Grellner, who is an attorney and owns the law firm RJG Law, and he specializes in tribal law, especially tribal law related to the federal government and tribal law, state government and tribal law, and a whole variety of other issues. So he is someone who has been following this closely and really understands the issues that we're going to face. And finally, we are happy to have with us Professor Andy Spiropoulos, who is the Robert S. Kerr Senior Professor of Constitutional Law at Oklahoma City University Law School. And he is the Milton Friedman Distinguished Fellow here at the Oklahoma Council of Public Affairs. And we are very pleased to be associated with him and to have him as part of this conversation. I'm going to start with AJ. AJ, just kind of give us a rundown of what was the case and what is this all about?
Well, thank you for having me on, and thank you for putting me on a panel with not only a professor that I've always truly regarded all 4 times that he graded me, but also with Mr. Grellner, who is very much a true scholar when it comes to tribal law issues. So let's start back even before 2005. Let's even go back into the 90s a little bit, where occasionally from time to time you would see individuals at the court file an appeal at the Court of Criminal Appeals. Most of the appeals, I would dare to wager 98%, if not greater, of appeals are filed by contract defense attorneys who work on hundreds of briefs a year, and some of them sometimes insert a creative argument or two here and there. And going back even before Mr. Murphy, we had people that would file briefs or file a proposition within their brief, usually a final one just kind of as a throwaway argument, that would say something to the effect of, I'm a tribal member, this was tribal land, therefore the state has no jurisdiction over me. That very rarely, it never was accepted. And then Mr. Murphy came along. Mr. Murphy committed a horribly gruesome crime that we won't discuss here, but he committed his crime in the bar ditch off of a state highway. And that's what the original issue was about with that case, was whether or not the state highway belonged to the state or it belonged to the tribe. And I was at the Court of Criminal Appeals at the time. I worked for Judge Gary Lumpkin at the time that this question came to us, and the court ordered that an evidentiary hearing be held. And at that evidentiary hearing, the landman that traditionally did work for the Creek tribe testified in that evidentiary hearing that this was state land. So the answer came back to the Court of Criminal Appeals, and my boss, Judge Lumpkin, wrote a very lengthy opinion explaining why the land was state land. And I had a very special part of researching that for him. But the answer that we came back was that his claim was denied. Interestingly enough, I took the bar the next year, and it was the criminal law question on the bar that year. So I feel fairly confident I got that one correct. But the case continued on. In 2007, claims were made in the federal court. Claims were later made in 2012 in the federal court. Mr. Murphy was perhaps the first example of somebody who significantly and persistently continued to raise the claim beyond the Court of Criminal Appeals and in the federal courts. Each time it was denied in the federal courts until he got a decision from the 10th Circuit in 2017. I think it was 2017, if I recall. And there he had Chief Judge Timkovich was the head of the panel, and the panel 3-0 decided, you know what? Yeah, the reservation was never disestablished, and they used a test or an analysis called Solem, which came out in about 1984. Very important decision in tribal law cases, and they said that that the Court of Criminal Appeals did not apply Solem to the analysis, and therefore a reservation exists. A little bit of a backstory is that yes, Solem was actually used in the case that the Court of Criminal Appeals decided, but that's old history now, I guess, at this point. So Mr. Murphy took his case, or the state actually appealed the 10th Circuit decision to the Supreme Court. And at the Supreme Court for Mr. Murphy's case, there were only 8 justices that could participate because Justice Gorsuch had been on the 10th Circuit when that case was there. And so we don't really know what happened, but the belief is that the case was locked 4-4 with possibly, I would presume, a couple of the justices just not quite sure how to craft an opinion that really kind of reached their goals. And so the case sat for a bit until Mr. McGirt filed the same exact claims, you know, right after, or not long after, the Murphy case stalled. And the full court took that up, including Justice Gorsuch, who wrote the opinion for the majority, saying that, well, of course a reservation doesn't exist, and really kind of taking the case in a completely different direction than it originally started out in, but really also taking Solem and kind of turning that into a much more expansive analysis than was originally done. And so now we are left in a situation where all of this time, unbeknownst to many, a reservation has existed in Oklahoma. And how do we unwind that history and get back to where a reservation can be properly in place? And what sort of jurisdiction lies with that? And are there state and federal laws that need to be unwound or are no longer effective as a result of that? The first decision to come out of McGirt actually just came out earlier or late last week, if I recall. It came out of the 7th Circuit, and the 7th Circuit has applied it, McGirt, to Oneida Nation versus Village of Hobart, which is a village in the city or the state of Wisconsin. And they have actually applied it in a civil authority way to say that the Oneida Nation is not required to get a city permit for its annual fall festival. The Big Apple Festival is what they call it. Traditionally, an organization would have to get some sort of a permit from the city to hold their event, really usually more for notice purposes. But Judge Diane Sykes, who's a great Federalist Society member, well-regarded judge, the panel decided unanimously that McGirt applied and that the tribe was not required to get a permit for any activities because the reservation, despite the fact that the reservation goes into city limits. So that's kind of a brief summary, and I know that we're going to have some back and forth in a little bit, but that should provide you at least the base history of where we are and how we got to where we currently are as we are now contemplating what I believe will be decades of litigation to try to fully understand and contemplate the ramifications of the decision.
Great, thank you. Rick, in a previous conversation a week or so ago, I heard 1889 Institute's Ben Lepak ask the question, how do the tribes see sovereignty? Can you tell us a little bit about what the tribes might be thinking in terms of what is sovereignty and what they might want out of this?
Yes, thank you, Rick, and thank you, AJ, for that historical lead up into those two cases. I guess it depends on which tribe you talk to about it and what their angle is coming from. Sovereignty has always, in a broader sense, been about the ability to regulate and oversee and control internal tribal affairs. The question always was, what did that really mean? And over time, that became, self-governance. Then it was extended to tribal members. And then in the later cases, it was about natural resources. So that's kind of the broader sense, but initially it was obviously about economics, because if you look at the history of it all, the tribes effectively had, their ability to defend themselves and provide for themselves taken away in an economic sense. So then those things happened. The case that really kind of brought it to light was, in this context, was Montana versus United States, where there was a rule up in Montana. There was a reservation that had non-Indians living on it. And there was a decision that basically said that, tribes, whether or not a non-member was subjected to the tribe's jurisdiction was whether or not they consented, and whether or not it dealt with, internal tribal governmental affairs. So the question always became, what was internal tribal governmental affairs? So that's kind of what it's about. But as it's all played out and tribes have expanded their economic footprint, it's become more to those who have done better on that end. So sovereignty has expanded in their view to what other governments across the globe would see as sovereignty, is effectively expanding their footprint, obviously to control what tribal members do inside their territory and sometimes outside their territory in the Indian Child Welfare Act context. And then it became about economics, expanding their footprint to be able to influence context in other governmental affairs, just like commercial operations would or foreign governments would. So it's become quite, it's in the eyes of the tribal beholder, but essentially it's very acutely viewed by a tribe because they know what it is when it's taken away. And so it's the rallying cry for everything that that could be argued under the umbrella. And depending on what economic situation this particular tribe in, it's viewed more expansive or not. But at the end of the day, it came down to basically controlling what the tribal members do, and then the natural resources under its domain. And so I think what the tribes would like to see as an outcome, there's really two different sets of tribes in Oklahoma. There's the 5 civilized tribes, who this decision arguably could affect directly by reestablishing their reservations. And then there's the other 34 tribes in the state that at one time, most of them had a reservation, but those boundaries were arguably disestablished in several decisions, the latest being the Osage-Irby decision in 2009, which cited the magical language in the treaties that effectively disestablished, but left them with their governments, left them with jurisdiction over their allotments and anything that they had in trust or was Indian country for each tribe. So I think that as a broad matter, they would obviously like to see the decision left in place. And then any decisions that need to happen, they, especially in the creeks, they've stated would like to have agreements for non-tribal members' jurisdiction and police powers and taxation and things like that. But the tribes in Western Oklahoma, obviously, we like to say, we were always in the back seat, or Western, Northern, the ones that don't have the reservation areas. We feel like if it's not done right, we could end up in the trunk economically, because we're basically in a position where the rules were applied differently to us, and therefore we, as a broad sense, and there's few notable exceptions, were not given the ability to put a casino and trust, you know, on every wide highway. And so therefore we didn't get the jump on the land run for the economic angle like a lot of the tribes in the East did. So that's kind of where it's at. And but as a broad sense, I think they would like to see the decision upheld.
Thank you. Andy, so this case was specifically about high crimes and the Creek Nation. But already we're seeing, as AJ mentioned, it's being applied to other areas of jurisdiction and even outside of the state of Oklahoma. So kind of what is the scope of what we might be dealing with here?
That's a great question. It's extraordinary. It's a matter of extraordinary scope. And I think that, as Rick just talked about, you have to understand what sovereignty means to all the Indian tribes. They view themselves as a separate nation. There's a reason the court calls them the Creek Nation, subject only to the federal government, not to the state at all. So to the extent to which this is tribal land and they are sovereign, they are not subject at all to the state of Oklahoma unless they have an agreement. The state of Oklahoma or the federal government says otherwise. And for most of our history, that has been in Oklahoma, that has worked. There has been a working relationship for the last several years. But what this decision does is basically erase 100 years of legal development and legal agreements and completely remakes the charter of government in Eastern Oklahoma. We have 100 years of development, over 100 years of development in this state based on exactly the opposite legal assumption, 180 degrees opposite, now completely upended. And I think the reason why this kind of snuck up on us and we didn't think about it very seriously, a couple of reasons. One, everyone just kept talking about this in the criminal context as if the criminal law was the only thing at stake. That was never the case. It was always about all the law. It was always about all the sovereignty. But everyone just kept thinking criminal law, criminal law, criminal law. People are going to be let out of prison. People are let out of prison. That there's a lot of truth to that. But everyone just ignored the larger context of this by focusing on the criminal era. The other part of it is that no one actually believed this was going to happen, which was a complete and utter mistake. When it was clear that the court was divided 4-4 after the initial arguments, and just Gorsuch was the only person left based on Gorsuch's record in the 10th Circuit, it should have been clear to everybody that there was a really good chance this was going to go the tribe's way. But no one wanted to believe that. Nobody wanted to think that they would upend 100 years, and no one really prepared for what was going to happen. So I think we have to step back and understand what this all means. What this all means is that Eastern Oklahoma, 1.8 million people, the 5 tribes are the central locus of sovereignty in those areas, period, right? Unless the federal government says otherwise. That means 100 years of governance by the state, right? Unless there is an agreement with the tribe or the federal government or the federal law saying that the state jurisdiction is in place, is gone. And that means you're going to have to renegotiate everything. I think what most people believed, and with some cases, that if this outcome happened to the extent to which they thought about it at all, that the tribes and the state, with the federal government acting as the guarantor, would basically sort of agree to basically do things the way that they've always been done, so as to not create huge problems in terms of litigation and unsettling of existing policies, with some changes in criminal law. I think you can't ignore, I think in terms of what the motivation of the individual litigants in this case were, this is a lot about the death penalty. The idea was that we had death penalty opponents who wanted to get this out of the Oklahoma courts because they didn't want these people to be executed. So I think when people thought, take care of that, we'll find some way to try to figure out a way of dealing with criminal jurisdiction. I think that's the Attorney General was thinking. We'll get an agreement. Nobody wants to mess up criminal jurisdiction. We'll get that done, and we'll just do everything the way that they were done before. We'll get this agreement in place. The feds will basically put it into law, and we'll just move on, and things will be mostly the way they've always been. That's not going to happen, right? Because I think the tribes have very quickly woke up to the fact that, oh my gosh, right? We now have enormous leverage to get a whole bunch of other things that we want in terms of taxation and regulation. It's never going to get better than this. And you have to understand that all this happened at a time in which the tribes no longer believe in Oklahoma that they have the upper hand politically, or at least the complete upper hand politically. The big tribes, remember, are used to getting pretty much everything they want from state government. And while this was going on, all of a sudden the tribes found themselves in the fight with the governor. And the tribes for the first time said, oh my gosh, there are large parts of the state government that are not happy with us, that are trying to drive a hard bargain with us. We're no longer guaranteed to have a good relationship with the state government. And now we find ourselves, not just in this case, but several other cases they've won in the last couple of months, with massive amounts of leverage they never had before. And they feel the need to use it because they no longer feel comfortable with the entire state government. So now they're in a position where they now have the upper hand in the negotiations. They also feel nervous about their legal and policy position. And they're therefore not going to just simply say, let's go back to the status quo and let everything on. They're going to say, no, there's a price that needs to be paid, that we have to protect ourselves. There are things that we want to do, revenue sources that we're going to want to take, areas of regulation that we may want to do. And it's really going to be more about the tribes deciding what they can and can't do, and how much you're going to be able to get the federal government to intervene. And the federal government could change its complete nature between come January, right? And what the federal government's willing to do in terms of helping the state versus the tribes could be completely different in January than it is right now. And the tribes know that. So I think that what you have here is you're going to have a negotiation over who controls government in Eastern Oklahoma. And the state is going to have to figure out what it can and can't live with, as will the tribes.
So there's a lot of issues to be sorted out here, but let's start with the one that might come at the end of the conversation. What's the fix? How do we fix this problem? Andy, I'm going to start with you.
Well, I think the most direct fix is the state and the tribal governments come to an agreement on how to divvy up powers as best they can. It's hard to see forward, but they can. Really, it's about what changes do you want to make to the existing system we've had for 100 years. Where are we going to cede state jurisdiction now to the tribes, because the tribes now have theoretically the upper hand. And then once that agreement gets put into place, and then I think the federal government will come in and ratify it by passing a federal law, putting into place the amendments to tribal sovereignty that agreement will entail. But I think if you're looking for Congress, your members of Congress or the administration to take the lead in making this deal for Oklahoma, they're not going to do that. What they want is for you to come to them with the deal. So this will be a federal statute, but it will have to be crafted based on a negotiation done in Oklahoma, because I don't think the federal government wants to take the lead in this, and I don't think they want to be involved. This is too Oklahoma centric for them to do.
Hey, AJ, you look like you're ready to jump in. What's the fix?
Well, I think that there's a few things, and I think the professor is correct. Is that really a full-scale statute proposal is the easiest fix, but is maybe not the easiest fix. And I think it's exactly for the reasons that all three of us have kind of alluded to, is now each of the civilized nations has to contemplate, we have this authority, what is it, and what are we willing to give up or exchange or trade, or how do we make this work with the state? And I don't think that answer is going to come quickly. I think that the bigger answer that may come more quickly is to do some piecemeal issues. For example, one of the issues that I've heard has begun to arise within the city of Tulsa is around property crimes. Somebody comes and steals my new expensive grill, and they hold a party down the street on my grill. Police go to arrest them, and the one who stole it says, "Sorry, I'm a tribal member. You have no authority over me on this." That is happening in Tulsa right now. And so the city and the state can't prosecute. The federal government may not have the means currently to prosecute. And so while they're trying to figure out what to do, most of these property crimes are probably going to go under prosecuted, at least for a short time. The intents to distribute. If you have drugs with intent to distribute, which usually under state law requires a certain quantity to be involved, some of those are the issues that are probably going to slide through the cracks initially, as more of the focus is placed on murders, rapes, kidnappings, the sort of crimes that actually fall under the Federal Major Crimes Act. And Professor Spiropoulos made a really important point too, is that really most of this whole case, the McGirt, the Murphy, these sort of claims, Mr. McGirt wasn't on death row, but most of these claims really arose by people that were on death row in the state system. And why is that? That's because under the Major Crimes Act and under federal law, the tribe has to agree to federal government offer, going through with the death penalty. And tribes historically do not do that for their members. And so really that's how this whole genesis started, was an attempt to get around the death penalty by many of those that would appeal to the Court of Criminal Appeals. So I think that what you're going to see, if anything, and it's going to be a little bit, I don't think you're going to see anything soon. But I think that when you do see something, it will be something around criminal jurisdiction. It will be some sharing of authority or a full understanding of authority. I know that we've seen the principal counsel or principal chief of the Creek suggest that they would prefer to do most of these through compact with the state. I think probably some of this can get done with the state, but I think it's probably more appropriate and more thorough and more full if we actually get it done with the federal government.
Rick?
Hey, this is Rick. This is Jonathan Small. When Rick finishes, I want to make sure I comment about OCPA's position on the solutions and the fix that are needed. Thanks.
Sure. Rick, so how do you see the fix? How do you think we get there?
Well, I think both of these guys have basically outlined what the issues are, and I think they kind of have pointed the road of probably where it ends up. But if you think back in the historical context, not that this is going to happen. In 2007, there was a ruling that out of the 10th Circuit that basically, in all former reservations in Oklahoma, the environmental laws for tribes could impose their own environmental laws, and there was a lot of uproar in the tribal community when a midnight rider was placed in an environmental bill that took away all authority for environmental laws from any former reservation. So obviously, that is always hanging out there. A one-line bill in some either appropriations bill or some bill of more substance. But the other side of it is that the decision itself only applied to the Major Crimes Act. So when we do have all these outflows from it that are theoretical and could well come into play, but it only specifically applied to the Major Crimes Act. So there was another case about 15 years ago called City of Cheryl versus Oneida Nation that came out of the Supreme Court that basically applied common law theory of latches, which is statute of limitations, to the tribes asserting, and this is why it was so interesting, to the tribes asserting jurisdiction over 300,000 acres in upstate New York. That was in the land claim context for the Non-Intercourse Act, but you can easily see how a reservation fits inside of a land claim, because if the tribe owned the land for that period of time, it would by definition include a reservation. That was an 8-0 decision written by Justice Ginsburg that basically said, centuries have passed and that's too long to come back and claim jurisdiction effectively. And so those equitable relief options have not been explored here. And so there's other ways that, these things could make their way back to the court, because those other 4 tribes and anything outside of the criminal context weren't specifically included. But I agree with these 2 guys. It's going to be a very interesting road ahead. The tribes obviously have an interest in getting something done in the short term, because they have exposure from an equitable standpoint, and they have exposure from legislation, like what happened on the environmental issues in 2007. So I think that's what you're seeing drive some of their things. The problem is on the tribe side, you have 5 different tribes with 5 different interests. You have you have the Creeks, who everybody said, oh no, we'll work something out. But now that they have taxing authority over downtown Tulsa, if I'm the Creeks, why would I ever give that up? Okay. And you look at some of their other issues, the Creeks were never, and I've been involved in litigation over where they put, where the Chickasaws and some of the other tribes put casinos all along the borders of their areas in well-traveled roads that affected the tribes in Western Oklahoma's casino markets. Well, the Creeks don't have those issues because most all their casinos are either located on land that's been restricted for over a century or was owned by the tribe. I can only think of one casino of theirs that is not questionable on how it was brought into trust. Well, you have the Cherokees, Chickasaws, and Choctaws that have 60 casinos, and Bill Price knows all this, that were put into trust for agricultural purposes, and they were building the casino almost the same day on most of them. So we challenged those issues. None of this is not public, and we haven't been successful at that. But they all have different issues. The Choctaws and Chickasaws would probably like to sell water to Texas. They had the water deal in 2016. The Cherokees have founding governmental issues that they weren't recognized until the late 70s that they would probably have to clean up between themselves and the United Kituah Band of Cherokees, who were recognized back in the 40s. So they have some governmental issues that they would like to clean up. The Seminoles, they're in the middle of everything, and they have lesser of an economic footprint, but they have quite a bit of oil and gas. So I'm sure that they don't want to give up their taxation rights under for double taxation on gross production of oil and gas. So there's a whole lot of different issues among these different tribes, and if you put those treaty and one issue even between the Choctaws and Chickasaws, you always seem to be on the same page. But if you look at the historical map, there's a hook at the southeast corner of the Chickasaw area that's right south of Durant. Well, what's in Durant? The Choctaws' #1 casino. They don't want a casino 15, 20 miles south of them on the way to Texas, right? So everybody in this deal has a different interest between those tribes, and trying to get them all on the same page is not going to be an easy task. And so you come back to the Creeks, are the ones that actually won the case, and their position is not unreasonable. Let's do these agreements over non-tribal members in the short run. If long run, there's something to do, but given their stance, nobody can blame the Creeks for their position at this point. And how it plays out is going to be very interesting.
Jonathan, you want to make a comment from the Oklahoma Council of Public Affairs perspective?
Yes, I think it's very important, and I apologize that I am not in video form. Our 5th daughter was born, so that's why I'm having to do it all phone today. But a few things are very important as it relates to McGirt. So first of all, let's be very clear. McGirt raped and sodomized his wife's 4-year-old granddaughter. Let's also be very clear. Current Oklahoma politicians and former Oklahoma politicians, Representative Tom Cole, former Governor Brad Henry, former State Senate Leader Glenn Coffey, former Oklahoma House Speaker Chris Steele, former Attorney General Mike Turpin, former State House Speaker T.W. Shannon, former U.S. Representative Dan Boren, and others signed onto a petition agreeing with McGirt's position. Why is that important? McGirt was going to be put away forever till the rivers run dry, as some might say, whether it was done under the badge of someone from the state or someone federally. So we know for a fact that the Chickasaws and the Choctaws who filed that brief, who have a great relationship with Glenn Coffey and Mike Hunter, I'll talk about that in a minute. We know for a fact that there's things that they wanted that had nothing to do with criminal jurisdiction. So, and from the standpoint of what's best for all 4 million Oklahomans, it's ludicrous for the state of Oklahoma to get in an uproar about criminal jurisdiction, because who cares? Either federal law enforcement is going to put away rapists and murderers who are Indians or commit those crimes in reservation, or the state will, or it's going to still happen. It would have been the state before. So the state is in a very bad position when state officials, namely Mike Hunter, continue to beat their chest about the fact that the most important thing to Oklahoma is public safety. It's not, because Gorsuch and 4 liberals just told the federal government what they need to do. They just told them, strap up, guys, you need to go hire more FBI agents and U.S. attorneys and U.S. marshals and however you're going to pick up rapists and murderers and major offenders. When you notice the deal that was rolled out by Hunter, who's received by far massive amounts of contributions for the tribes, when you saw what he rolled out, he intentionally rolled out a measure that said the state got, which is kind of hilarious, the state got to have all criminal jurisdiction, and then gave up tax, regulatory, and environmental provisions regarding tribal citizens who now are in this brand new reservation. Let's talk about what that looks like. What's that look like? That now means somebody's neighbor, if they have a card, they get a different set of rules than someone who doesn't. That means they don't have to pay income taxes. That means they don't have to pay property taxes. That means they don't have to pay sales taxes. I've been working in state government since 2003, or around state government policy. It will be words that I should not use in front of our 8-day-old Megan, an absolute you-know-what cluster for the state of Oklahoma to be in a position where it has to compact with Native nations in the same manner that it currently has to compact regarding cigarette, tobacco taxes, and motor fuel taxes, wherein they're giving to those Native nations 50% or 50 cents on the dollar, everything that they collect. In an environment where the Oklahoma Supreme Court has already ruled that the Oklahoma Tax Commission has no jurisdiction whatsoever and no ability to investigate the revenue that's reported at gaming facilities or anything else like that, or a strip mall that's bought for the tribes. It would be a joke what the state of Oklahoma government would look like, and the tax increases that non-tribal citizens would see in Oklahoma. So as Gorsuch said, the simple fix, and what every Oklahoma lawmaker should do if they're swearing on the Oklahoma Constitution, which was ratified under the notion that the reservations were disestablished, they should be fighting for Congress to do what Congress and the federal government thought they did, which is that they had disestablished those reservations. That's the only option. That's the only option anyone remotely conservative should advocate for. And until you start there, it's basically just an argument about a society in which there's two sets of rules where some will pay taxes and some won't. So I just want to make sure and get that clear. People are being very dishonest with Oklahomans. One, they're not telling people what McGirt did or what Murphy did. And then two, they're not being honest about people who said that they were represented Oklahoma first, but in the terms of Tom Cole, Glenn Coffey, and others, at every turn have looked at the interests of the Chickasaws or the Choctaws. Another place where this comes up, everyone keeps talking about this great water deal that, curiously enough, Glenn Coffey was also involved with. Here's what's fascinating. Here's one thing that I will appreciate that Mike Hunter is saying. He's telling people there isn't another reservation that now exists like the one that exists here. What does that mean? That means in Oklahoma, unlike other places, when you're on the reservation, it has to take care of everything. They got to take care of their own roads. They got to take care of their own schools. They got to take care of their own water. None of that happens in Oklahoma. Under this new decision, and if we don't get Oklahoma politicians who fight for Oklahoma like the Native Nations are fighting for themselves and their interests, here's what's going to happen. Oklahoma will never be able to sell water to Texas, but guess what? Tribes in the South will be able to, and guess what? They won't care because all of their citizens, the vast majority of their citizens are getting their water needs provided by major cities like Oklahoma City, Tulsa, Lawton, and others. So these are real problems that have to be discussed, and that state policymakers who took an oath on the Oklahoma Constitution, which represents one Oklahoma, and all 4 million Oklahomans need to make sure that they're in line with. So I just wanted to make sure I shared that, Rick, because it's being lost on some people, the ramifications of what's going on.
So we have a question from the audience about the double taxation issue. And so I want to throw that out to the panel and see what you guys think about it. There was a Cotton Petroleum Supreme Court case, and there's the possibility of double taxation for non-Indians. I suppose the tribe would impose some sort of a tax, and Indians and non-Indians would have to pay that, but then the state taxes, the non-Indians would not have to pay. So essentially, the Indians wouldn't have to pay the state taxes. So essentially, the non-Indians would then be double taxed because they're paying the state tax and the tribal tax, whereas the Indians are only paying the tribal tax. What do you guys think about that issue? Does it only apply to oil and gas? Is it only the Seminoles and their wellhead tax, or could it be sales tax in Tulsa, or what could it be? Andy, you're muted. AJ, you're muted too.
Can you hear me now?
Yes.
Yeah, I think this issue is going to come up all the time. I think it's a great question. And you saw this a little bit with the Attorney General Hunter and his argument about concurrent jurisdiction in criminal cases, in which you're going to have a lot of complicated issues. Some of them have arisen, some of them haven't. But the scale of these double taxation claims are going to come up. And theoretically, that's right? When if you're a non-Indian doing business in Indian lands, the possibility of you being taxed by both jurisdictions makes sense. Theoretically, it can come up all the time. And so, and the question is, and it's a great question, but will the state actually do that? Will the state actually, if it can tax, will they double tax? And the answer a lot of times is going to be no, the state's not going to do that, because the legislators will be voted out of office if they do. So what's going to happen is that the state, even if the state, does theoretically have the fiscal authority to raise revenue on particular activity, they're simply not going to do it. And they may do it in some instances because maybe they'll use it as leverage over the tribe, because the tribe will lose customers because people won't be double taxed. Maybe, you'll see all sorts of games like that. But there are going to be lots of situations where the state theoretically will have the power to do it because they're dealing with people who are not tribal members, but they won't be willing to do it. So they'll just, not only they will lose de jure power, they're going to lose de facto power too, because they won't be willing to use the power they actually have.
Real quick, in the oil and gas sense, Rick.
Yep.
In 1936, the Oklahoma Indian Welfare Act included a provision that allowed the state to assess production taxes on oil and gas. And so that was the start of allowing the state to assess, and particularly the oil and gas sense, of allowing them to assess gross production taxes on tribal lands, allotments. And that was followed up in the mid-'80s with a case out of the Supreme Court called Hickory Apache versus Marion that allowed severance taxes. And then you saw it out of the Cotton Petroleum was double taxation, where the state of New Mexico was asking to be able to tax, but they didn't have the same provision in the Oklahoma Indian Welfare Act, though the state of Oklahoma had, which allowed the taxes. And so then you saw, so clearly it was allowed in 1936 double taxation for the tribe to tax, gross production tax, and the state. But then in the allotment context, a case out of the 10th Circuit in 1996, Mustang Fuel Corporation versus Harrison, extended it to the allotments. So the short answer is, at least in the oil and gas context, it was the authority and in the tribes, most of the ordinances exist for the double taxation. And so that is obviously a big issue for the Seminoles. On the sales tax side, these guys are all scholars. They remember Potawatomi versus state of Oklahoma from 1991, where the state or the tribe had an obligation to turn over the state the taxes on non-tribal members. But the problem with that is there was no remedy, because you can't just walk into the grocery store at Fire Lake in the Potawatomi Nation and grab the tax money. So there had to be, that was the reason for the compacts that came out of it. And in that context, you could claim that cigarettes, for example, that were going over the roads that the taxes weren't paid on were contraband. Well, how do you do that when the entire eastern half of the state is a reservation, and they don't have to come through Oklahoma to move the product? So there's a lot of issues. It's going to be interesting.
Well, and even on that issue that Richard raised there at the end, the Cougar Den case out of the Supreme Court last year, I think really, and that was a Justice Gorsuch decision that candidly I think was probably decided correctly. That one was involved using state highways to transport fuel to the reservation. It was purchased in Oregon and then traveled for about 30 miles into the Yakima Reservation. And the state of Washington wanted to try to enact taxes for use of the road for transporting in that instance. And in that case, the Gorsuch said, no, you can't do that. I do think that one was properly decided based on the treaty language. That was a good textual decision in that case. But I think it's a really difficult thing, because if you follow all of the taxation law that the Supreme Court has laid out over the years, a non-member that works on tribal land, that lives on tribal land, including allotments, cannot be taxed by the state. A non-member that lives in tribal lands can be taxed by both. And so that's where some of these difficulties are going to come. And I think, unfortunately, if Professor Spiropoulos is correct, the real problem that we're going to have is that getting less revenue from Eastern Oklahoma will turn into getting no revenue from Oklahoma, and also recognize that our requirements, the funding of activities in Eastern Oklahoma does not go away. And so what will happen is an economic need to figure out either A, to raise revenue, or B, come up with new creative taxation means to try to fund services at the current level that they are, or try to reduce them statewide so that we can make up for the loss of revenue in the eastern half of the state.
I want to raise two other questions really quickly. We're running out of time, and our panelists have been gracious to agree to be with us until 1 o'clock, and it's about 1 o'clock. If you guys could hang with us for just a couple minutes, I got two more questions. The first one, and Rick, I think I'll throw this one at you first. What about the Indian Child Welfare Act? Is this going to have an effect there? Is this a problem?
Well, obviously it's not really going to change much that's going on. But so it may highlight a thing in the few instances, but I don't see it really changing much in the Indian Child Welfare Act context. But I don't specialize in that area, so I would defer to the other two panelists if they have a different opinion on that.
Either of you have a thought about that?
It's not an area that I practice in. Obviously, Oklahoma was front and center in a decision, I believe it was 2012, of the U.S. Supreme Court around that issue. I think that it is generally settled law, but that doesn't mean that there's not going to be questions that arise out of that, particularly around jurisdiction, because there could be argument, I'm not saying that there is, but there could be argument about non-members within the territory having some involvement there with the tribe. I don't think you're going to see that, to be clear. I want to be very clear that I don't think you're going to see that, but you could. Somebody could try to throw it out there in a desperate attempt to try to hold on to their child and not have their spouse receive the child. So I think you will say that, but I forgot in my notes a little bit ago that Richard brought up the Montana case. That's a very powerful case, and it's a very significant case that shouldn't go understated, and was so important that when the Attorney General came out with his agreement, that he proposed with the 5 nations, the language of Montana was actually in the body of the proposal. So recognize that I think any question of jurisdiction or issues, a lot of that is really going to revolve, particularly on the civil side, around questions of Montana versus United States.
So I want to raise this issue. We touched on it just briefly, kind of brushed by it. But do the tribes have the capacity to enforce laws, to pursue criminal prosecutions, even the tax and regulation side of it? Seems like they would have to do a lot of gearing up to be ready to do that. And at the same time, the federal government, if the U.S. attorneys and the U.S. marshals have to become the law enforcement agents, are they prepared to do that? What's it going to take for us to get there? Representative LePack has noticed that the Creek Nation has issued a statement about creating a Reservation Protection Commission. So it looks like they might be moving in that direction. I've just seen the headline, haven't really had a chance to read it. But do you guys have any thoughts about capacity and what it's going to take for the tribes and the federal government to be ready to take on these challenges?
I think some would argue that the tribes were not ready for the jurisdiction that they were handed a few short weeks ago, but they have it in many instances now. So that would be my comment, that whether they're ready or not, they better continue to get ready.
I would just say I would agree with that. I think the tribes differ in their capacity, so you're going to have different answers for different tribes. I do think that they did not expect or did not anticipate the level of ramp up that would be expected if these decisions came out this way. I don't think anybody did. So I do think that is that is something I'm sure that they're worried about. But I also think from the state's perspective, that is the state's greatest point of leverage. That's what the state has going for it, because it will be costly for the tribes, particularly some of them, to ramp up to this level. And so that is the state's best negotiating point for trying to keep the status quo. that why should we use all this money to build government capacity when we already have a government that's been doing it, and let's agree just to keep things the way that they are with some changes so that there's something in it for both sides. But that is a fundamental question, and the easy answer is no in most instances. But that's what you would expect.
Rick, you have any thoughts about capacity?
No, I think a lot of tribes have recognized that you know, at this point in time, they may not have the capacity. But one of the ways that was promoted to deal with it, at least in the criminal context, was to deputize all the state officials and do agreements between the U.S. attorney and the local state officials, so they could, you know, have dual hats in dealing with these issues. I don't know if that's going to be on the table going forward or not. One issue that was brought up, and maybe we didn't flesh out, I don't see a lot in the Indian child welfare. I don't practice in that area a lot. But one thing that did come out of that Baby Veronica case that was interesting was the court pointed out that was 3 drops out of 246 tribal member. And you may see challenges, and you see one coming out of the Fifth Circuit along those lines as who is a tribal member, because we now have Cherokee tribal members and a whole lot of them that are, you know, 1 drop out of 2,000. And so at some point, you know, how that relates to federal rights, tribes have always been able to determine, and sovereigns have always been able to determine their membership. But when you have, especially in the federal funding context, limited resources, how does that work when most of the tribes I represent have a blood quantum requirement, and those funds get determined by membership, and they also get determined by land base? Here now you have, you know, tribe, the Cherokee Nation, that has 380,000 members and somewhere between 4,000 and 5,000 quarter bloods. And you have tribes in Western Oklahoma that, like the Kiowas, Comanches, Cheyenne, Arapaho, that have 15,000 to 20,000 quarter bloods. And they don't have 8-9 million acres to be able to expand the federal equation. So what has been the way the federal money has been disproportionately appropriated in at least the small tribes position over the last couple, 3 generations will become more acute if now they're able to claim 19.7 million acres as a land base to basically increase their federal footprint. So with, you know, limited federal funds, the smaller tribes will get less money yet. So, and that will relate to Indian child welfare because of the ability to basically claim those membership rights when dealing with it. So it's going to be interesting.
Rick, I think you may have answered this earlier, but I want to come back to you about a small tribe issue. So we focused the discussion mostly on the 5 civilized tribes, but there are 39 tribes in Oklahoma. And if the court is applying this decision to a tribe outside of Oklahoma, is it going to apply to all 39 tribes in Oklahoma? Is it just the 5? Is there like 6 or 7 of them who are in and 25 of them who are out? Or how do we know the answer to that question?
Well, the answer to that in a broad context is simple. It's, I think AJ said it's a tribe by tribe, you know, treaty language. But when they did the Dawes Commission, most of the tribes in Western Oklahoma, and there was always an issue about the Osage, got the same language in most of their treaties about ceding all right, title, and interest of every kind and character. And so you had a couple decisions that come out in the 50s called the Ellis decision, Ellis v. Page, and then you had the Irby decision in 2009 about the Osage reservation. You've always had the Ponca and the Otos that basically said their boundaries, even though they still had trust lands and they had allotments over which they could exercise jurisdiction, were disestablished. Most all those tribes in Western Oklahoma have that language because their executive order or treaty reservations were held in trust. And so when they came to do it, they applied the same language. The Osage, there was always a question, like I said, because their mineral reservation was held in trust. But for Eastern Oklahoma, those tribes were held in fee simple. And so when they were brought here, they wanted the same title that they felt like they had in the old colonies, which was British title. So they wanted fee simple title, and so that's what they got when they came here, and they were all issued patents. But there's a difference in the language, and each tribe is free to have its own interpreted. And some may claim, they didn't get all and everything of all of it. Obviously, we've done that in a few of the military reservation cases. But most all those Western tribes that had trust reservations, which they all did, had that language which just established those boundaries. And it may not be 100%, but it appears to be very broad. That's why you have really two different classes of tribes in Oklahoma. And as some of them said, we've been in the back seat because we've always required more of a blood quantum requirement. And so we get less federal money because we want to protect who we are. And it's not fairly distributed. But now, because we have less of a footprint from a property standpoint, our jurisdiction is checkerboarded. We may have 10,000 acres, 50,000 acres, depending on what tribe. They've got 19.7 million acres. That's going to be even a further burden on the equation. So that's where it is from their standpoint.
So when do we have this all sorted out? Are we looking at 2 years from now, 5 years from now, or 20 years from now when we have this figured out? Or I guess we're looking at an 1833 case. So are we looking at 100 years before we get this thing figured out?
Boy, I'll start out by saying I've been telling clients decades, and by that in my head, I mean maybe 40 years. If you think about generally some of these water fights over water agreements, those stretch. It's not uncommon for those to go 30 years. So I don't think it's inappropriate to say 40 years, but it's probably even longer, because now that we have reservations, any tribal decision that comes out of the U.S. Supreme Court can throw a wrench in what we currently understand.
Andy, how long do you think we're looking at here?
Either it'll be settled right away or never. And I'm going to bet on never, right? If there's no big deal, no universal deal, then I think what you're going to see, as Aja said earlier, you're going to see trench warfare. You're going to see a statute here, a statute there, a settled issue here, a settled issue there. They'll try to get as many things settled piecemeal, the criminal situation, get that done, and then they'll just work on the other things as they go along. And it's all going to depend on who has the power in Washington at the time about what you can get done. But to come back to Jonathan's point earlier, who in Oklahoma, right? Which major politician in Oklahoma, I suppose besides the governor, right, is going to take the position that we need to disestablish the tribal reservations? I mean, who's going to take that position that we need to bring back the status quo, right? At this point, every major leader, right, has been in favor of increasing tribal sovereignty and tribal power, protecting the state in their own view as well. But so who's going to be pushing in Washington, right, for these positions? It's hard to see.
Rick, how long till we get this thing resolved?
I think they summed it up pretty well. I do think that you could see some of the equitable arguments on some of the non-Creek treaty language going back to the court on the city of Cheryl issue and things like that, which could have an effect. But we'll see how it goes. Time will tell. Because that case only applied to the Creeks.
Okay. Well, everyone, thank you so much. We really appreciate your expertise. We appreciate you enlightening us to the extent that you can. And we've learned a lot. There's a lot of issues out there to be discussed, and we're a long ways from resolving them. But you've certainly helped us at least understand a little better what the issues are. And we really appreciate your time today. Thank you so much.
Thank you. Enjoyed it.